Hello and welcome to this lecture on understanding the Uniform Civil Code. The Uniform Civil Code, UCC, is one of the most debated provisions of the Indian Constitution. Enshrined in Article 44 of the Directive Principles of State Policy, it directs the state to secure for the citizens a uniform civil code throughout the territory of India. The UCC aims to replace religion based personal laws with a common set of civil laws governing marriage, divorce, inheritance, and adoption. Its purpose is to promote national integration and gender justice by ensuring equality before law, irrespective of faith. However, the proposal has generated deep ideological divisions. Supporters see it as essential for true secularism and equality, while opponents fear it threatens India's cultural diversity and minority rights. The debate is not merely legal but philosophical, concerning the balance between individual rights and group identity. The UCC represents the unresolved tension between constitutional morality and religious pluralism. Its implementation remains an aspiration reflecting India's cautious approach to reconciling modern legal ideals with the realities of a deeply diverse society. The idea of a uniform civil code predates the Indian Constitution. During the British colonial period, criminal, contract, and evidence laws were secularized, but personal laws remained religion based. The colonial government avoided interfering in marriage and inheritance to maintain political stability. Reformers like Raja Raman Roy and Sir Syed Ahmad Khan, however, advocated social change within religious frameworks. The Lex Loci report of 1840 recommended uniformity in secular laws but left personal laws untouched. By the early 20th century, reformist movements demanded codification of personal laws to eliminate gender inequality. The nationalist leadership, including Nehru and Ambedkar, viewed a common civil code as essential for nation building. Yet, they recognized the need for gradual consensus rather than imposition. The historical evolution of the UCC reflects India's struggle to modernize law while respecting plural identities. It was not simply a legal project, but a moral and political vision to harmonize unity with diversity under constitutional democracy. Constitutional context, Article 44 in the Directive Principles. Article 44, found in Part 4 of the Constitution, expresses the state's duty to secure a uniform civil code. As a directive principle, it is not legally enforceable but serves as a moral guideline for governance. The framers included it to promote unity and equality across communities. Dr. B.R. Ambedkar argued that while religion must remain a matter of conscience, law should be uniform for all citizens. At the same time, leaders like Naziruddin Ahmad and Muhammad Smail sought safeguards for minority personal laws. The compromise was to include the UCC as a goal rather than a mandate. Article 44 thus becomes a constitutional ideal symbolizing harmony between reform and freedom. It reflects the vision that secularism in India means not the denial of religion but equality before the law. Moreover, the way freedom of religion has been dealt in the Constitution is enough to substantiate that this freedom has to be dealt in with very delicately and in a very sensitive manner, and it is vulnerable to the largest number of restrictions in the entire list of the fundamental rights. The UCC placements in the DPSP highlights its aspirational nature, binding in spirit yet flexible in practice, pending social consensus and maturity. The Constituent Assembly discussion on the UCC were among the most passionate and divisive. Dr. Ambedkar, K. Munshi, and Aladi Krishnaswamy Iyer argued that a common civil code was essential for unity and gender justice. However, they emphasized that personal laws, being social rather than religious in nature, could evolve through legislation. But Muslim members such as Muhammad Ismail and Poker Sahib contended that enforcing a uniform code would violate religious freedom under Article 25 and 26. So, leaders adopted a cautious approach, supporting gradual reform. The Assembly finally adopted Article 44 as a DPSP, acknowledging the ideal while deferring implementation. Ambedkar clarified that the UCC would apply only when citizens were ready to accept it voluntarily. These debates reveal the dual nature of Indian secularism, committed to equality but sensitive to diversity. The Constituent Assembly's decision ensured that the UCC remained an aspiration rooted in persuasion, not coercion, symbolizing faith in democratic reform over legislative compulsion. And this is what the different communities have done over the years, be it Christians or Parsis. Secularism versus pluralism, the core constitutional tension. The UCC debate captures the philosophical tension between secularism and pluralism in India. Secularism demands equality and uniformity of laws, regardless of religion, while pluralism values cultural diversity and community autonomy. Indian secularism, as articulated by Rajiv Bhargava, follows a model of principled distance, where the state neither withdraws from nor dominates religion, but engages with all fairly. Implementing the UCC tests this balance. Proponents argue that pluralism must not justify inequality, especially gender based discrimination. Opponents fear that uniformity could undermine minority rights and cultural identity. The Indian Constitution attempts to reconcile both through Articles 25 and 26 that deals with religious freedom, and of course Article 44, which is a reform directive. Thus, the UCC debate is not about religion versus reform, but about finding an ethical equilibrium between equality and identity. And the way this provision has been incorporated and the Constituent Assembly debates reflect that the state should not rush to implement Uniform Civil Code, but give enough time, as we have given almost after more than say 5 or 6 decades, that the state is now preparing grounds for Uniform Civil Code. It reflects India's unique model of secular governance, one that respects diversity while striving for justice through democratic consensus rather than authoritarian uniformity. Gender equality and the arguments for reform. The strongest argument in favor of a uniform civil code arises from the principles of gender equality. Personal laws in many religious traditions historically discriminated against women in inheritance, divorce, and maintenance. The Constitution, through Articles 14, 15, and 21, guarantees equality, non discrimination, and dignity. Proponents of the UCC argues that these rights must override religious customs that perpetuate inequality. Also, the chapter on fundamental right to freedom of religion starts with restriction, which includes subordination of freedom of religion to other parts of to other sections or other provisions of this part, meaning thereby that if there's a conflict between freedom of religion and say right to equality, then right to equality will prevail. Cases like Shah Bano in 1985 and Shara Bano in 2017 demonstrated how courts have invoked constitutional morality to protect women's rights. Feminist scholars, including Flavia Agnes, argued that internal reform within communities has been slow and fragmented. A UCC, if designed sensitively, could provide a uniform standard of justice while respecting diversity. However, critics caution that imposing uniformity without dialogue could provoke alienation. The goal, therefore, is not homogenization but harmonization. achieving equality across religions through shared moral principles grounded in the Constitution. Minority apprehensions and cultural autonomy. Minority communities, particularly Muslims, Christians, and Parsis, have historically viewed the UCC with apprehension. Their concerns stem from fears that it might erode a religious freedom and cultural identity. The experience of colonial interventions in personal laws reinforced the belief that religion should remain autonomous from state control. Minority leaders during the Constituent Assembly debates emphasized that faith is integral to community life and any uniform law must emerge through dialogue, not imposition. The UCC is often perceived as a majoritarian project, especially when reform discourse aligns with political agenda. To build trust, reforms must emphasize equality for all, not uniformity imposed by one group. Though there is a provision of dialogue, and the Constituent Assembly debates also talk about dialogue. But how long India can wait for these dialogues? The time is enough. The time is now ripe to engage in meaningful dialogue, to erase the practices which are not gender just. Cultural autonomy is protected under Articles 25 to 30, ensuring freedom to manage Article 29 to 30, ensuring freedom to manage religious affairs and institutions. Therefore, any move towards a UCC must reassure minorities that secularism in India means equal respect, not erasure of difference. A reconciliation between equality and identity remains the foundation for any sustainable reform. But while Christians and Parsis have accepted this need to gradually reform their personal laws, to initiate reforms from within, the Muslim community is an exception. Judicial pronunciation. Judiciary has periodically reignited debate on UCC through landmark rulings. In Sarla Mudgal versus Union of India, the Supreme Court criticized the government for failing to implement Article 44, emphasizing that uniform laws are necessary for gender equality. In John Valamatham versus Union of India, the court struck down discriminatory provisions against Christians, reiterating the need for uniform justice. And similarly, in Sharabano, the courts invalidated triple talaq, linking personal law reform with constitutional morality. However, courts have avoided mandating a UCC, respecting its status as a directive principle, but the message is clear, through these judgments that time is ripe for to move towards uniformity, to move or to communities to accept that socially unjust provisions should be removed. The judiciary's role has been persuasive, advocating reform while upholding religious freedom, but giving a clear message to different communities. These judgments also show that UCC is an evolving idea, and now we should start working towards it. Through judicial activism, the court has filled a number of gray areas and has tried to amend the socially unequal or unjust provisions and practices, upholding the dignity of women. But the reforms at the major scales are to come from within the community, as they have in the case of Christians and Parsis. Law Commission's report of 2018 marked a significant shift in the official perspective on the UCC. After extensive public consultation, it concluded that a uniform civil code is neither necessary nor desirable at this stage. Instead, the Commission recommended reforming individual personal laws to remove discrimination while preserving diversity. It proposed gender neutral marriage, inheritance, and guardianship laws across all communities. The report emphasized that equality can be achieved without enforcing uniformity. Though what it called equality within diversity. It argued that the focus should be on justice and inclusion, not sameness. The Commission's stance echoed the spirit of the Constitution that now we should start working towards gender justice, and personal laws which are highly discriminatory need to be reformed. We have to remove discrimination from the personal laws. The message is very clear. Though the report of 2018 reaffirmed that the path to just civil code lies not through compulsion but through consensus, education, sorry, though the report of 2018 uh, reaffirmed that the path to a just civil code lies not through compulsion but through consensus, education, and democratic dialogue. But the message is clear that personal laws are discriminatory and we need to do away with the discriminatory provisions. And that this is how we are, of course, indirectly moving towards the ultimate goal of social justice. Once the communities start accepting their practices as gender unjust, obviously the path towards uniform civil code will be ready. Uh, Theoretical models of uniform civil code. There is no single model of a uniform civil code. Rather, several theoretical frameworks exist worldwide. The liberal model advocates a single secular law applicable to all citizens, regardless of faith, similar to system in France or Turkey. The pluralist model allows coexistence of multiple personal laws under a common constitutional framework, such as in India and Indonesia. The hybrid model proposes harmonizing core principles such as gender equality and human rights across communities while retaining a religious diversity in ceremonial aspects. Indian scholar and jurists argue that the UCC must follow a hybrid or incremental approach. Complete uniformity may disregard the country's complex cultural fabric. Instead, gradual convergence through codified reforms and mutual adaptation could ensure equality without coercion. The theoretical goal of UCC is not to erase different but to align community laws with universal constitutional values. I think the time is ripe for the government to come with their own model of UCC why, through a consultation or in consultation with different communities. This way, we should come up with a model which evolves organically, respecting both individual rights and group identity within a secular democratic ethos. The global experience with civil codes reveal diverse approaches. In France, the Napoleonic Code 1804 established complete legal uniformity rooted in Enlightenment ideals of equality. Turkey adopted the Swiss Civil Code of 1926, replacing Islamic law to modernize family law. In contrast, Indonesia and Malaysia maintained dual legal systems combining secular and Islamic laws. Israel also recognizes religious courts for personal matters. These models highlight that legal pluralism is common in multicultural societies. India's challenge is unique because its constitution protects both equality and cultural autonomy. Unlike Turkey's state enforced secularism, India favors consensus based reform. The global comparison underscores that successful legal systems adapt to social realities rather than imposing uniformity. But all these successful legal systems adhere to gender equality and gender justice. So, India's UCC should aim for inclusivity and dialogue with the ultimate goal of social justice and social equality and final empowerment of women through personal laws, through equal property rights, equal right to maintenance, and equal divorce rights. The doctrine of constitutional morality plays a central role in evaluating the UCC debate, introduced by Dr. Ambedkar and reaffirmed in later judgments like Navtej Johar 2018 and Shara Bano 2017. It requires that all laws, including personal and religious, adhere to constitutional principle of principles of liberty, equality, and dignity. Constitutional morality thus becomes the ethical compass guiding reform. It demands that while religious freedom under Articles 25 to 26 must be protected, it cannot justify discrimination because Article 25, the very onset of Article 25, makes it clear that the freedom given under Article 25 are subject to other fundamental freedoms given in this part of the Constitution. So, if at any stage the freedom of religion is in conflict with rest of the fundamental rights, then the rest of the fundamental rights will prevail, not freedom of religion. The UCC interpreted through this lens is not merely a legal reform but a moral commitment to justice. It ensures that personal laws evolve in alignment with the constitutional morality, balances faith with fairness, ensuring that reform strengthens rather than undermines secularism. Now, this principle transforms the UCC from a political slogan into a constitutional ideal, one that unites India's plural society under shared values of justice, equity, and mutual respect. Uh, Political dimensions of the UCC debate. The Uniform Civil Code has often been entangled in political discourse. While the Constitution envisioned it as a social reform measure, political parties have used it to mobilize identity based support. Proponents claim it promotes gender justice and national unity. Critics view it as majoritarian tool targeting minorities. But which minority? Christians and Parsis have already moved much ahead in reforming their own personal laws. So it is only with the Muslim minority that the issue gets so much politicized. The politicization of the UCC has made genuine dialogue difficult with the Muslim minority. Electoral rhetoric often overshadows constitutional reasoning, reducing nuanced issues to ideological confrontation. Governments across decades have hesitated to act decisively, fearing backlash or alienation of minority voters, particularly the Muslim voters. The result is policy paralysis despite judicial advocacy. Depoliticizing the UCC debates is essential for balanced reform. It must be presented as a gender and human rights issue, not a religious one. Only when UCC is detached from communal politics can it achieve the constitutional vision of equality and integration. Reform must be driven by consensus and constitutional ethics and not political opportunism. And then, moreover, the Christian and Parsis model can be put before the rest of the minorities who are reluctant to bring about required changes in the personal laws. Achieving gender equality while respecting faith traditions is the heart of the UCC debates. Critics of personal laws argue that they perpetuate patriarchal control over women's rights. Supporters of religious autonomy caution that abrupt reforms could alienate communities. But which community? Christians and Parsis have already accepted reformation and they have already reformed their personal laws. The balance lies in consultative reform, upholding equality without undermining faith. The Supreme Court's rulings in Shah Bano, Daniel Latifi, and Shaira Bano exemplify this approach. So, gender justice must remain the guiding principle, but reforms should emerge through public dialogue, persuasion, public education, etc. So, scholars emphasize that uniformity imposed from above risk resistance, while uniform through awareness builds lasting change. So, this is what the other communities have done. So, what we need is that the ideal outcome should not be sameness but fairness, where gender equality strengthens rather than weakens India's rich pluralism and inclusive democracy. And of course, the Muslim minority has to realize the importance of gender justice and gender equality. For minorities, the UCC debates evokes deep concerns about identity and representation. Historical mistrust, especially post-partition, shapes perceptions that uniformity might lead to cultural assimilation. Any movement towards a UCC must therefore prioritize inclusion and consultation. Policies should emerge from dialogue with minority institutions, scholars, and community leaders. Therefore, implementing the UCC requires reassurance that the aim is not to erase identity but to guarantee equal dignity for all. A successful UCC must reflect both diversity and justice. Acknowledging the national integration thrives on mutual trust and shared commitment to constitutional morality rather than forced conformity. The path to implementing UCC lies in gradual inclusive reform. Immediate uniformity is neither practical nor desirable. Instead, codifying and harmonizing existing personal laws can create a foundation for eventual convergence. Gender neutral marriage, inheritance, and adoption laws across religions can ensure fairness while maintaining diversity. The Judiciary and Law Commission advocate dialogue based reforms supported by education and civil society participation. Building awareness about equality rather than imposing legal uniformity will foster acceptance. A phased approach, beginning with voluntary adoption of uniform principles, can pave the way for consensus. We are having the examples of Hindu Code Bill that started way back in 1955 and is under reformation till now. And gradually, the Hindu women has been made at par with the Hindu men as far as property rights are concerned. We are having the example of the Christians and the Parsis, wherein the reforms have emerged from within but are gradual, and over the years they are moving towards the idea of gender equality. The only exception is the Muslim community, but I'm hopeful, I'm positive that the way the judgments in Sharabano has been accepted, it will pave way for a healthy acceptance and wholehearted acceptance of the idea of gender equality and protection of women's rights. Uniform Civil Code represents both an aspiration and a challenge within India's constitutional journey. It symbolizes the quest for equality, justice, and integration amid diversity. The Constituent Assembly saw it as an ideal achievable through gradual social evolution, not coercion. This is what we have done. Over the years, Indian state never forced, except for the Hindu Code Bill, which was abruptly, imposed on the Hindu community, and that too the majority community accepted it without much resistance. While Christians and Parsis have come up with their own package of personal law reformation, and the reformation there have been gradual, not forced or imposed from above. The UCC debate reveals the core of Indian secularism, balancing unity with pluralism, reform with faith, and gender justice with religious freedom. People have to understand and realize that religious freedom is not absolute. Rather, it is subordinate to the well being and the bigger scheme of liberty of an individual. And freedom of religion is only a part of an individual's well being and greater charter of liberty. And women are no exception to that. And religious freedom, if at any stage collides with other fundamental rights like equality, dignity, then the freedom of religion has to be subordinated to these fundamental freedoms, especially human dignity, women dignity. Judicial interpretations and law commission reports, judicial and the public awareness, legal education are gradually creating a pro-women environment in the in the country. I think the goal is not to erase religious identity, but to ensure that personal laws uphold the dignity and rights of all citizens. So, UCC is not merely a legislative reform, but it is a reflection of India's moral and constitutional maturity. When achieved through dialogue, consensus, and trust, it will stand as a testament to India's unique model of secularism. But the time is now ripe because more than 6 to 7 decades have been given to all communities to work on these lines or to work on in these areas and to create enough consensus within their own community. Thank you.